Hello and welcome to Fire Away, Rudner Law's online Q&A show focused on the employment law matters, the issues that matter to you. My name is Stuart Rudner. I'm an employment lawyer and mediator and your host of Fire Away. Just a reminder, Fire Away streams online every month and our episodes are always available on our YouTube channel, our Facebook page, and on our website. If you have any questions, we'd be happy to try to get to them today. Feel free to either post them in comments on Facebook or on YouTube or tweet them to @RudnerLaw. And as always, we have a guest, and I'm very excited today to have Dan McGarry join us. Dan is the Director of HR at the Global Wood Group. More importantly, Dan is a tremendously experienced HR professional with extensive knowledge of employment laws, employment standards, occupational health and safety. He is a true resource and someone that I've spoken with on many occasions, publicly at the HRPA annual conference. And my biggest challenge with Dan as a guest on this show was figuring out what topic we should cover because he could discuss almost anything. So Dan, thanks for joining us today.
Thank you, Stuart, and I hope I don't disappoint. And in regards to your introduction to me, I'm also a post-secondary instructor, and this is very pertinent because of the different generations and how they view social media and their access to it and how they treat it.
And there's a perfect segue to what we're going to talk about today, which is partially social media. We're going to be talking about off-duty or problematic off-duty conduct, which can include social media, and what employers should be doing as far as dealing with candidates, with current employees, and also things like whether you become friends with your employees on Facebook and things like that, and whatever else we can cover in the next 20 minutes or so. So, Dan, thanks again for joining us. And I want to start off by talking about a very interesting situation that I was interviewed on CBC recently about. And I don't know if we have a graphic or an article on this one. This is the City of Hamilton employee who was recently discovered to have been a former leader of a neo-Nazi group. And when this broke, and it was one of the former city councilors who really made this public, made headlines, caused a lot of consternation amongst the folks in the city of Hamilton, because you've got someone who's not only an employee of the city, but an employee in the IT department of the city with access to confidential information of not only employees, but residents and other people of influence in the city, including city councilors. So this made headlines, not surprisingly. There were immediately calls for the person to be fired. The city has adopted a wait and see, or at least an investigate and see approach, of they're going to look to see what's actually happening. What's interesting here is usually when we talk about employees misbehaving online or publicly off duty, it's current behavior. So-and-so did something last night, and should the employer do something about it? And just, before I get to Dan, just want to make it clear that so everyone understands this. The law, despite the fact that we're now seeing a lot of people disciplined or dismissed because of online conduct, the reality is the law has not changed at all in the last many, many decades. The law has always been that by default, whatever you do online is your own business, or I should say off-duty is your own business. However, there have always been exceptions. And there has always been the potential for discipline or dismissal for off-duty conduct if it impacts the employer or the employment relationship. So if you're going online and doing something that will impact your employer's reputation, that can be cause for discipline. If you're going online and bashing your boss or your manager, that can be cause for dismissal. One of the examples, and I know Dan and I have talked about this offline, is the Ontario Hydro employee who was on camera outside a Toronto FC soccer game yelling at a female reporter offensive, misogynistic comments. And even though this had nothing to do with his job, he was not wearing an Ontario Hydro shirt, everyone knew where he worked. So it has an impact on the reputation of the company. The company decided to take immediate action and fired him. That was done largely as a PR move. Ultimately, as many people may not be aware, he was reinstated after he grieved the termination. But the point was, this had an impact on the employment relationship and on the employer, and the employer took immediate action to distance themselves and make it clear they don't tolerate that type of conduct. So getting back to the City of Hamilton employee, Dan, what would you do if something like this happened to your company, where you found out that one of your employees was previously known as a head of a neo-Nazi group or something equally offensive?
Well, I'm going to go to this in a sort of a roundabout way, Stuart, because you, of course, alluded to the Millhaven Fibers case, which sets the ground rules for off-duty misconduct. And that case was decided in 1967. So we're talking roughly 52 years out of date, if you remember what technology was like in 1967.
I have to admit I don't, but
well, I remember my first cell phone, and I was paying, I think I paid $2,500 for it and 50 cents a minute, and the battery was good for 15 minutes. So we've greatly advanced. Regarding the Sean Simoes case, there was part of the uproar was the fact that he was on the sunshine list, and you felt that somebody who was on the public payroll for that much money should be a little bit more mature and aware of his surroundings. Somebody replicated what he did just recently after a Toronto Raptors game and was immediately dismissed. And we don't know if, I believe he was non-union, so he's probably going to be out of luck. There will be no reinstatement.
Yeah. Although he may still call his name for wrongful dismissal.
Yes, that's correct. Yeah, he may call you. But
I haven't heard anything yet.
Yeah. Regarding the city of Hamilton, we mentioned briefly before, there is a paid hockey coach out in British Columbia who was dismissed for neo-Nazi postings. And rather than follow what the city of Hamilton employee did, which is denounce and say that he's no longer believing in that, this hockey coach, after losing his job, went full on Nazi and has become very direct in his hate postings. Now, with technology, the employer has far more access to information. We've almost gone back to the 19th century where you hired people based on you knew their family going back for decades because they lived in a small town and they needed the reference from the local upper class. We have access to everybody's past. If it's online, it never disappears.
Right.
But it seems that in our hiring processes, there is no set format yet for a lot of different companies on the type of checks that they do to ensure that they don't fall in or step into this type of minefield. Previously, we had all kinds, and I could cite dozens and dozens of cases of people being hired who lied about their credentials. The Toronto Stock Exchange hired somebody to a senior executive role who claimed to have an MBA and didn't. York University, of all places, hired somebody who became a VP who claimed to have a degree which he didn't hold from a university that doesn't even exist. Now, how hard would it have been for them to have fact-checked that? A quick social network search of public domain information is something that companies should be conducting on a regular basis as part of their pre-screening.
So let me ask you, Dan, have there been cases where you've chosen not to hire someone because of things that you found online?
I don't want to go into my specifics based on confidentiality, but let's just say that we do a complete screening of what's available. Now, there are other issues that we come upon because we're such a diverse, multicultural environment in Toronto. You may have people who are posting in their native or their birth language, or even not even in our alphabet, but in the alphabet of their birth language. So how intrusive is it to then have this translated? And then what about the dark net? They might be posting things on what, these secretive sites. Do you go into those sites and do you really want your company internet server exposed to these sites? Because who knows what sort of malware or spyware can then be embedded into your equipment.
Although I guess you could get a third party, because I know there are companies that will do those checks for you. So that's and do you know of companies that are going onto the dark web as part of their hiring process?
No public companies, but I'm sure that there's a lot of companies that are involved in, say, special government that should be doing it if they're not.
Yeah, I mean, it's interesting. I said this just before the show started. I was doing a presentation last night for the HRPA in Toronto, and our crowd was not as large as we'd hoped because of the Toronto Raptors celebration, but we still had a decent crowd. And was talking about the hiring process, and we're now in 2019, I still get pushback when I say you should be doing a social media check before you hire anyone. And I still have people say, are we really allowed to do that? Or should we do that? And that often leads to a bit of a philosophical debate. But my view, and I know you share this view, is that it's public information. There's nothing wrong with going out, reviewing what's publicly available. You then make your decision as appropriate, but there's nothing wrong with getting that information. So bring it back somewhat to the City of Hamilton employee. This is not a hiring situation. This is someone who's been employed for many years. And whether or not this information could have been disclosed or discovered when he was hired, not the point anymore. The point is it's now come to light. And I've seen similar situations where you've got somebody who's employed, and now you have an employee comes to you in HR and says, I just found out that so-and-so who works down the hall from me is a neo-Nazi, or posts these horrible misogynistic comments online, or posts violent videos online, and I don't feel safe working with that individual. So how does someone in HR handle that type of situation?
Well, you just mentioned the words that make it cross the line. I do not feel safe. Because of course, under the Occupational Health and Safety Act, we now have our duty and obligations to ensure that it's a safe workplace. And every company under provincial jurisdiction has to have a policy regarding investigating these and must investigate. And there was just a recent article in the Globe and Mail about...
I'll just get you off for 1 second, Dan, just to be clear, that's Ontario jurisdiction, because we have people across the country. So that's Ontario, which has the mandatory investigation. But I think you and I would both agree, as a best practice, even if you're not in Ontario, once you hear those words or hear that there's a risk to safety or this harassment, you're going to want to investigate.
Of course, yes. And then it becomes an obligation that if there has been an act of harassment, an act of violence, that then crosses the line, and you have probably just cause, proportionality, everything else. But I would make the case, if you're a good HR person and you want to find a way to make the case, you're going to make the case.
Yeah, well, you may take a run at it, but as you and I know, you may not succeed. So I mean, it's an important point to make. Just because you find out someone's done something wrong, even if it is particularly egregious, that doesn't necessarily mean you have just cause. And you mentioned proportionality. It's also contextual. You do have to look at things like how long the person was employed, whether they have a record before. There's a whole lot that goes into it. I'm not sure if you can see it behind me, but my book on just cause is there. It's about this thick because of how complex the law is. But, to your point, once you make that decision, you don't want the person there anymore. It's only a matter of how. You may have to package them out. You may have to give them some money, but you're not going to keep them in the company. I just want to digress. I know you're familiar with this case. It's the EV logistics case from out west. And this was also a neo-Nazi case. And this, to me, is still a fascinating decision, because in that case, what happened fairly quickly is one employee went to HR and said, we as a group have found out that one of our colleagues has a website, or a blog, I think it was actually, that strongly supported the neo-Nazi ideology, idealized Hitler, basically confirmed, and had offensive comments about a number of races that were represented in the workplace. And as a group, they said, we're not comfortable, we don't feel safe working with this guy. So the company fired him. And in that case, there was a wrongful dismissal claim, and the individual won. And what was fascinating to me is I always thought that if there was a safety concern amongst the colleagues, that would basically win the day, and that the dismissal would be upheld. What seems to have happened in that case, and you have to read between the lines somewhat in the judgment, is the individual in question was a very young guy who lived at home either with his mother or his grandmother, clearly had a difficult life, immediately took the blog down and was quite apologetic. And it seems as though the judge looked at this guy as being far more naive than evil, if I can put it that way, and truly believed that although he put up all these offensive posts, there was no intent, there was no issue or no concern that he would become violent or in any way would act upon those beliefs. So that to me is still a bit of an anomaly, but it's a similar case to the City of Hamilton one or others that we've seen where either past or current off-duty conduct comes to light, and even though it's still offensive, it's not just cause to fire the person.
Well, it goes down to remorse, admitting what happened, and chances of reoffending. Okay, which are all contextual and looked at as well. And in the example that you just gave, those all come into play. In the Hamilton case, he says he's no longer, and those were old posts. So again, the city has to look at that. And then we also have to look at, is it a union or non-union workplace?
Yeah, well, that's a municipality. I assume it's union. But yeah, you're right. I mean, and the problem, of course, is that as soon as the story breaks, if you go online, if you listen to talk radio, you've got everyone yelling for this person to be fired immediately. And I think the city did the right thing by saying, we're not going to do that, but we are going to look into it because, like you said, he claims to have renounced those views. Maybe he has. And I think it's also important to note, and I forget exactly how long he's there, but he's not a new employee. He's been there for a while, and there have been no incidents that have been reported, no issues of him disclosing or taking confidential information. So that will certainly weigh in his favor to say he's been employed for a long time. So this should not be cause for dismissal.
Exactly. Yeah, that's very, very true. I mean, you have to look at the past behavior. He hasn't crossed the line in the workplace. He hasn't crossed the line recently, and he says that he's no longer following that. So, and you have to, the duty of, you have to believe him in this case, unless you can prove that he's lying to you.
Yeah, and look, if he's lying, there probably would be evidence. I mean, it gets back to the point you made at the very start of the show, which is, now employers have this wealth of information available to them. So there'd probably be something online that would indicate that he is still involved with that movement, if he is. So let me switch the question around a bit. We've talked a bit about the hiring stage and doing the background checks. What's your, and I don't want to get into specifics of your company, but do you know that of companies that are doing ongoing checks of what their employees are doing online?
Yes. We actually have in our terms and conditions of employment a social media and company supplied equipment terms in there, which allows us to check because, as you know, there is a reasonable expectation of privacy now on employer supplied equipment. And some companies I know, when you sign on each day, it pops up what's required and you have to agree before you go in.
Right.
So the company can continue to see what you're doing with their equipment. As far as ongoing searches on people's social media and Facebook, we don't conduct that, and I'm not quite sure of any companies that do it on a regular basis, but there is a generational issue here. As I mentioned, I teach, and so I have access to students from all different age groups. And you have one of the generations at least make their entire life public, and they don't seem to be able to discern the difference between public and private activities. And this can create a real problem, not only if you're doing checks after, but also in the pre-screening, because it gives you information to all kinds of protected grounds. And so when does this cross the line that you know different things about them that you shouldn't know about them? I think that they really should receive more training in this sort of thing.
You're talking about the individuals or HR?
Both.
Good answer. I know we've talked about this before. I mean, that's the risk with doing the social media check is you may stumble upon information that covers or touches upon protected grounds. Like it's very easy to go on Facebook and find out the person's religion, or that they have kids, or that they are undergoing chemo treatment for cancer or trying to have kids. And then the biggest risk is now that you know, of course you can't unknow, and if you choose not to hire them for perfectly legitimate reasons, they might turn around and say, well, I know that you found out that I have cancer, and I believe that's part of the reason why you didn't hire me. So HR needs training on that point. And I mean, the one or two pieces of advice that I always give, and I'm sure you probably heard me say this before, One is do the social media check, but it should never be the person making the hiring decision who does it. Have a third party do the check and filter out all the irrelevant information, give the decision maker a report that has information relevant to the hiring, to the job, so that if you're ever cross-examined, you can quite honestly say, I had no idea this person had children or cancer or whatever the case may be. And the second point is make a note of all of your reasons for either hiring or not hiring. So we chose not to hire Dan, not because of his religion, but because of the fact that he didn't have enough experience. So that way, if you're ever called or cross-examined 6 months or a year later and you may have forgotten that candidate, you'll have clear notes as to why you made your decision.
Plausible deniability is.
Yeah, no, it's a really great point that you make about that. And you mentioned policies briefly. I wanted to come back to that because I see it's very common to have policies for use of corporate equipment, but I mean, I'm certainly recommending for our clients that they have policies about off-duty conduct. We'll have a discipline policy which says you can, in certain circumstances, be disciplined for off-duty conduct, and also go further and say that we have the right to look online and see what you're up to, and if it is anything that impacts our reputation, our relationship, then you may be disciplined for that as well. So I think it's very important to make that clear to all of your employees so that they can't claim they had no idea that what they do on their own time could come back to haunt them.
And of course, depending upon their level of fiduciary, they're held to different standards. Right? An entry-level person will be held to a much different standard than somebody who is a corporate controller or somebody who represents the company publicly.
Absolutely. I mean, if you're the face of the company, then it's going to be a much higher standard, but it could even be a lower level employee if they are. I mean, the worst one is still, to me anyways, the Amanda Todd situation from many years ago. And Amanda Todd, as many people know, was a teenage girl who was bullied online, eventually committed suicide. And there was a Facebook page put up in her memory, and somebody went online on that page and wrote a comment that said, "Thank God the blank is dead." And so horrific, also stupid, because of course it's Facebook, so everybody could identify who posted it. And I think it took about an hour for people to figure out where the person worked.
Mr. Big and Tall.
Big and Tall Menswear.
Yeah.
So someone reached out to Big and Tall Menswear and said, "This is what your employee is posting online, and we know that he no longer works there." I never heard of a claim, so I'm not sure if he got any money or not. But to your point, I mean, that's the type of thing you want to regulate, because even though I don't know what his role was at Big and Tall Menswear, I mean, I'm not sure if he was in sales, he wasn't the face of the company. No. But he was fired because he could have damaged the reputation
of the company. Yes. Exactly. And then we're going back now. This is 2011 or 2012. So this is not a subject or topic that should be new to HR practitioners. This is something that's has been emerging for probably a decade.
Yeah, absolutely. You're 100% right. And yet, a lot of people are still not really haven't turned their minds to this yet. So, and like you said, education on both sides is necessary. I'm mindful of time because, as I said it would, the time has flown by. And we did promise we'd at least touch upon the issue of what do you do in HR when people in the company want to be your friend on Facebook or your connection on LinkedIn or follow you on Instagram or whatever social media I'm not even aware of yet. How do you handle that?
Well, I actually host information sessions for at least one college for prospective HR students. And one of the first things we ask is, why do you want to be HR? And if they tell me it's because I'm a people person, I then ask them to go into sales or marketing because they've chosen the wrong profession. As an HR professional, you are privy to confidential information. You are involved in disciplines, you are involved in dismissals. And therefore, I don't believe as an HR professional that you should be socializing with the people that you work with, because at one point or another, there's going to be the time when you are going to have to sit across the table from them for a reason that might upset them. So having too much knowledge of your life, your personal life, is not something that I would recommend at all. And then we also talked about as a teacher, how much should I have with a student? And the Ontario Learn Internet teaching program, in your contract, you are required to only communicate with students via the college email system. You can't go on any social media, telephone, personal meetings, no other communication with them. And so it's kept strictly on a professional basis.
Yeah, which makes sense. And I think you made some great points there. And I'll ask the one follow-up question that I often get, because I usually make similar points that if you're in HR, and even though you may be a people person, and Dan, I actually think you are a people person, and you can have great relationships with many of your staff, but you probably don't want to be connected on Facebook and learn a lot about their personal life. The question I often get back is, okay, what about LinkedIn? Can I connect with them on LinkedIn?
LinkedIn is a different, and I think it's based on a professional basis. And that I would say you can with your coworkers and people such as that. LinkedIn, I think, is acceptable. Just don't use it to disperse personal information. Yeah,
I think that's great advice, and it's probably a good place for us to wrap up for now. So, Dan, as we know, we could have gone on for hours.
Yeah.
And for those who don't know, Dan and I, is it 3 years in a row now we've done the HRPA conference?
Correct.
Yeah, 3 years in a row now, the HRPA annual conference, which is the largest HR conference in Canada. And Dan and I have been on the agenda with no agenda and no script, no slide deck. It's been an open Q&A session, and has gone over tremendously well. And we have just answered whatever questions people have had. So that's why I said that, I could have had you on to discuss any topic, Dan. But thanks for being on today. I really appreciate you joining us.
Well, thank you very much. Hope to do this again sometime.
Sounds great.
Okay. Thank you.
All right. And Rob, I guess now it's my chance to fire away. All right, so my topic today, this is directed to individuals, and it's more of a plea than a rant. Please stop treating your employment contracts as a formality. And Rob, if you could put up that graphic we talked about. So we are all used to seeing something like this online. You want to read an article, see a video, and this comes up, and this is what stands in between you and reading or seeing whatever it is you want to see. So what do we all do when we see this type of thing? We click I agree without reading it. Or if it's one of those that makes you scroll down, we scroll through it and then click on I agree without even reading it, which is, some other lawyers may disagree. That's the reality of what we do. The problem is that's what most people are effectively doing with their employment contracts. They're being handed a piece of paper, or probably several pieces of paper, and they're just signing it without even reading it. And unlike those online things where maybe you're trying to, get through that web page on one simple trick to lose belly fat or whatever it is that you're going to, this is your livelihood. This is your job. This is your career. This is an employment contract which will fundamentally establish or remove your rights as an employee. It's critical, and it actually shocks us, within Rudner law, how often people sign off on these contracts without even taking the time to review them, let alone have them reviewed by an employment lawyer. And this is true for everyone. We have seen senior executives, HR professionals, lawyers, all of whom have signed off on contracts that dramatically impacted their rights without even giving it a second thought. And the argument I often get is, well, I saw it, but I didn't bother going to see a lawyer because I assumed the company knew what it was doing. And what I always say is, yeah, they did. And what they were doing was protecting their interests. There is very rarely an employment contract that is designed to protect the employee's interests. If you're being asked to sign a contract, it's generally for the benefit of the company. I'll give you a couple of quick examples of what we typically see. Biggest one is termination clauses. People sign away their common law rights to severance in these contracts. So imagine that you're employed for 8, 10, 15 years, and now there's going to be a downsizing and you get a severance package and you get 8 weeks. And we've had people sitting in this boardroom and they start off by being convinced that it's a mistake. The company must have screwed up. I've been there for 15 years. They owed me far more than 8 weeks. And we have to explain to them that no, when you started way back when, you signed a contract that limited your entitlement to the employment standards minimum. So 8 weeks or whatever the case may be is all that you're entitled to. And then to add insult to injury, we often see the same person who they just got their 8 weeks of termination pay, but they also agreed to a non-compete clause for 2 years. So they're now being told they're going to get 8 weeks of pay, but they can't basically work in their industry for 2 years. And yes, I'm sure some of you are thinking that's probably not enforceable. It's very possible you can challenge that non-compete, but it's going to cost you a whole lot of time and a whole lot of money to do so. Whereas if you'd read it at the beginning, you may well have been able to take it out and not have to go through that fight. Or we've also seen people who have been signed off on clauses that say you can be relocated to any of our locations. So they just got notice that effective 2 months from now, they're being transferred, in one case, from Toronto to New Brunswick, and another case from New Brunswick to Vancouver. And they don't even have the right to compensation for their moving costs because the contract was very clear that they're on the hook for that. These are the types of things that we see far too often. And I hate to say this, but at the hiring stage, although everyone's excited about the new job, it's not the time for trust. It's also amazing to me how often I hear stories about how someone was promised something and they're told by the hiring manager that, well, I can't put this in writing, but I know we're starting you at a low salary. 6 months from now, we're going to review your salary. Or don't worry, I know that our policy says that nobody can work from home, but you can work from home 2 or 3 days a week. That's not a problem. Or I know that you're leaving your current job and giving up a big bonus. We're going to give you a bonus to make up for that. If it's not in writing, it's not in your contract, you have no right to it. So please don't trust the company in that regard. Employers are getting far more aggressive with contracts. And if you get the job, even though you're excited about getting the job, don't just sign off because you're probably signing away significant rights if you do. And one objection I often get is, well, who cares? I know the company's not going to negotiate with me. So what's the point? I can tell you quite honestly that we've helped a lot of people to renegotiate that initial offer. And a lot of times companies will just give it a shot. They will try to impose a very oppressive contract, knowing that if the person comes back, they'll negotiate. So in many cases, things are negotiable. If it's not, at least you're going to go in with your eyes open, knowing what you're giving up, and then you can make your decision. So I know it sounds self-serving. You need to go see an employment lawyer before you sign your contract, not your cousin who practices tax law or your neighbor who does real estate law, someone who specializes in employment law. And quick message to employers on a similar subject. If you're going to go through the process of putting contracts in place, make sure they're enforceable. Because the other thing that surprises us here at Rudner Law is how often people have contracts that, if challenged, would never hold up in court, either because they're badly worded, maybe they were downloaded offline, maybe they're taken from someone's previous job, or they're badly implemented. And I could go on for an hour about that, but the worst example and the most common thing is this. You hire someone, they show up for their first day of work, you hand them their contract and ask them to sign it. At that point, it's too late. They already had a verbal agreement, and that's why they're there that day, because you hired them and they accepted it. That's a verbal contract. You can't just replace it with a written contract unless you give them something new. So have them sign the contract before they have been hired. Otherwise, that contract that you have, probably not worth the paper it's printed on. So that's my 2 cents worth for today, and you got it here for free. That's all the time we have for today's episode of Fire Away. I want to thank Dan McGarry again for joining me for a great conversation, which could have gone on a lot longer, but I think we covered some really interesting points about how you deal with off-duty conduct, whether it's current employees or what people did in the past. Our next episode is going to be on July 16th. I'm going to be joined by Richard Salas, who's a senior financial consultant with Investors Group. If you have any questions that you'd like to ask in the meantime or suggestions for future show topics, you can send me an email at info@rudnerlaw.ca. Do want to remind everyone that past episodes are always available on YouTube, on our website, and on Facebook. And if you like our page or subscribe to our channels, then you'll receive notifications. Also invite everyone to keep in touch with Rudner Law in between Fire Away shows. You can sign up for our newsletter, and that way you'll get notifications of everything that we're up to, as well as updates on employment law. But as I always say, please remember that none of this replaces legal advice. If you think you might need an employment lawyer, such as when you get your offer of employment or when you're drafting your contracts, if you think you might need an employment lawyer, you probably do. So please feel free to reach out to us and we'll see if we can help you. Thanks, as always, to Rob for making this go so smoothly, Rebecca and Mark as well. Thanks again to Dan for joining me. And thanks to all of you for tuning in, and we'll see you next time.